Hello, welcome once again to Lehto's Law. I'm Steve Lehto. The other day we were talking about the situation in Massachusetts where the state would occasionally come into the possession of cars that had liens on them, but they would auction the cars and the liens would disappear, and then the lien holders would get left holding the bag, so to speak. And during that discussion, it became clear to me that many people don't understand what a lien holder is or how that works. So basically, what I'm going to talk about today is how a bank loan on an automobile sale works. Okay, so I'm going to try to do this very, very generally, but again, like I said, there's a lot of confusion in this area. So I'm going to try to walk you through the process and explain it at least from a lawyer's viewpoint, which is the same way that the courts look at it, which is pretty much how you need to know how things work in case you ever run afoul of this. So the first thing you need to know is that if you walk into a dealership, a car dealership, you want to buy a car, the prototypical transaction that I'm going to describe to you is a brand new car. This could happen with a used car. There's a couple other things going in there too, but we'll talk about first. You walk into a dealership to buy a brand new car. Let's assume you've got decent credit. So you say, look, I want to buy this car, but I'm not going to pay cash for it. I want to make payments on it. And they say, okay. So they ask you for some information. They run your credit. They determine that you are eligible for this. And they say, yeah, tell you what we're going to do. We're going to finance you over 5 years, 60 monthly payments. Put some money down, make some payments, and the vehicle's yours. So what happens then is you sign some documents, shake some hands, and next thing you know, you're driving off the lot in a brand new vehicle. Now, here's the thing, and I've done some research on this. I was kind of surprised. Michigan is in the minority of states, but there are 9 states in America, including Michigan, where if you buy a vehicle, the title gets sent to you. And so I've mentioned before that I have the title to my vehicle. And even when I've had loans on vehicles, I had the title in my possession. And I've had people say, you're out of your mind. That never happens. Well, it happens in some states. It just doesn't happen in all states. I can tell you I bought a car in California, and I was talking to the guy at the dealership about it. He goes, oh, by the way, he goes, you don't get the title. I'm like, I own the car. And he goes, doesn't matter. In California, at least at that time, the bank holds the title until you pay it off. Then they issue you the title with the lien holder information removed to indicate that you own the vehicle free and clear. But in Michigan, when you buy a vehicle, as I described with the loan and so on, they actually send you the title. Comes in the mail. 10 days later, you get a title. And it says right on it, here's the vehicle being described with the VIN and your name and address and a description of the vehicle. And then it says first secured party or lien holder, and there's the name of the people that you're making payments to. Okay? So if you look at the title itself, it says owner, and that's you. Lien holder is the bank. And I've had a lot of people say, well, Steve, the bank owns your car. No, they don't. You own the car. That's why it says you are the owner on the title. Now, I understand that people in states where you don't get to see the title before you pay the loan off might not realize that that's the case, but that is the case. If you saw the title, it'd say you're the owner. The bank is the lien holder. As long as you make payments, you own that car. You're the owner of that car. Now, I should probably explain a couple things to you. And I mentioned this briefly before, but usually how these transactions work is when you sit down and sign the loan agreement that actually says, I'm agreeing to make payments on this car, monthly payments, blah, 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 blah. It'll actually say you're making the agreement with us. And the document will say us and you. And it'll say us is the dealer and you are the buyer or the customer. And a lot of people don't realize that initially the loan contract is between you and the dealership. It's between you and the dealership. Now, I know people say, well, Steve, I went in, I was pre-approved with Ford Motor Credit. I mean, I knew I was going to get a Ford Motor Credit loan. It's not between me and the dealer. It's between me and Ford Motor Credit. Read the paperwork. The paperwork actually says there's a purchase agreement that says that you are buying the car from the dealer. There's a loan agreement that says you're borrowing the money to buy the car from the dealer. But the document then says someplace on it, this loan is going to be assigned to a lender, okay? But the initial loan is usually between you and the seller. And a lot of people don't understand that. They go, wait, that doesn't make any sense. Well, it makes sense, but that's just the way things have evolved. And what we're talking about is actually called a purchase money security interest. Purchase money security interest. And that is that the person who's selling you the vehicle is in essence saying, I'm loaning you the money or lending you the money to buy this car. And in exchange for me lending you the money to buy the car, you're agreeing to give me a security interest in the collateral, which is the thing I'm giving you, and that's how it works. And then what happens is they then assign the paper, they assign the loan to somebody else. Now that assignment might be a done deal, meaning that everyone knows that, hey, Ford Motor Credit has approved you, this loan's going to Ford Motor Credit. But the reason I'm explaining this process to you is that you have to understand in some states, and this may or may not be legal in your state, but I've done entire articles on this and videos on this, but in some states, if they take the loan documents and try to assign them to a third party, the bank, if the bank refuses to accept that and says, we don't want this paper for whatever reason, either we didn't approve it or something appears wrong, the paper then goes back to the dealership, and the dealership is holding the paper, and it makes sense because the paper describes them as the lender. Okay? So I've had people call me, they say, Steve, I bought a car, put a bunch of money down, I've been driving it for a month, the dealership just called me and said, I got to come back in and give them more money. And I always say, why? And they say, they claim there's a mistake in the paperwork or something. And here's the thing. I know there's circumstances where that can happen. But there's also circumstances where it's just a scam. Okay, it's called yo-yo financing or a spot delivery. Like I said, some states it might be legal under certain circumstances. You go in to buy a car on a Saturday, the bank's not open, and the salesman is convinced you're going to be able to get that loan. So they sell you the vehicle, you drive off the lot in it, and then when they send the paper to the bank goes, we're not going to finance these people, take it back, and they send the paper back. The question simply is, when you signed all your documents, did you sign an agreement saying what would happen if the assignment failed? If you didn't, they might get stuck holding the paper. I can tell you right now, I've had several cases in Michigan where my client bought a car, put the money down, drove off the lot, made his first payment, and the bank sent it back and said, we don't know who you are. Client contacts the dealership, they go, oh yeah, the financing fell through. You can return the car, we're going to keep your down payment, or you can just make, give us some more money and we'll try to shop your loan around. And my client goes, what should I do? And I said, well, go back and read your original document. It says that they're the lender and you're going to make payments to them unless it gets assigned to somebody else. Since they haven't assigned it to anybody else, make your payments to them. So my client starts making payments to the car dealership, which they don't like for some reason. Who doesn't want money? So remember, buyer, dealer, bank, okay? So in that transaction, when the title gets issued, whether it gets sent to you to hold or to the bank to hold, the title itself is going to show you as the owner. It's going to show the lien holder or the secured interest is the party to whom payments are being made. And as you might imagine, if you're thinking about all this, when I buy the car from the dealership and the loan documents say that they're lending me the money, and then they assign the paper and the bank, accepts that. What happens then is the bank then sends a check to the dealership to pay for the car, in essence. And then, and it's all factored together. And then you're making payments to the bank along the way, and the bank is going to make money off the interest on the theory that you're going to make your payments on time. Now, of course, if you don't make your payments on time or you do anything wrong, if you look at the document you signed at the dealership, that's the loan document, flip it over, usually on the back is where they put the ugly stuff. And on the back, it's going to say, if you default, we have all these remedies against you. And among other things, it's going to say, if you're late by 1 day, we have the right to repossess the collateral. And they're going to say, if you miss a payment, we have the right to repossess collateral. And they're going to say, if you miss a payment and then make a payment and get caught up, next time you miss a payment, we can repossess collateral. And they've got all these different things, but it'll often say we can repossess the collateral. And a lot of people mistakenly think that if the collateral gets repossessed on a loan, it's like, oh, we're good then, aren't we? No, you're not good. Because what it'll also say right in the document is, if we repossess the collateral, we will then do the following things. Or they'll say we can do anything allowed by law. And in Michigan and most states, what we were talking about here is a secured transaction. It's a transaction that has a secured interest being held by somebody, and what rights they have with that secured interest to try to make themselves whole when they're injured. It's all governed by Article 9 of the UCC. I actually have a reported case of the Court of Appeals in Michigan on it. Another story altogether. But the document itself might even describe all the remedies they have. So what happens is you miss a payment and whatever, and they repossess the collateral. You're not good. What happens is that's just the beginning of an ugly process, because the collateral is going to get taken to an auction. may not even be open to the public. It might be only open to like dealers. But as long as they dispose of the collateral in a commercially reasonable fashion, they're going to be okay by law. So what they do then is they take the vehicle to an auction and they sell it. And vehicles sold at auction are usually not sold at top dollar because the vehicles rolling across the lot are repossessed. People don't know what condition they're in. They could be trashed, whatever. And quite often the vehicles sell for way below book value. And so what winds up happening is they'll say, well, you owed us $15,000 in your car and it auctioned for $6,000. So we take the $15,000 you owe us, we reduce it by the $6,000, but then we had auction costs and towing costs and all those other, and they get to charge you all of that. And then they get to chase you for the deficiency. I've had people tell me that they have had a situation where they only had a few payments left and the vehicle got repossessed and somehow they still owed money, which is possible. If the vehicle didn't sell for much, and it's possible if it's a 3 or 4 year old vehicle and is in rough shape. So that's really what the problem is with respect to understanding your rights, is that people sign the document and they think, I'm making payments to somebody. And they never actually look in the backside of the document and see what all the remedies are that the bank has against you, because some of them might appear to be draconian in nature. It very well could be that your vehicle gets repossessed. They take it to auction and sell it. They create a deficiency, and now they're going to chase you for the deficiency. Oh, and by the way, if you have a cosigner, they might chase them first. We discussed that in a previous video. So, understand that all that stuff might and very well could happen to you if you don't pay attention to all these things that you signed at the time you bought the vehicle and borrowed the money. The other thing you should remember is there are also used car lots out there. And some of them will actually arrange financing with legitimate lenders, big lenders. But there are also used car lots out there that are buy here, pay here, where they are the lender. So literally when you're signing a document that says, you agree to buy the car from us and make payments to us, they don't assign the paper to anybody. They just keep the paper. But usually, and again, I'm painting with a very broad brush here, but usually buy here, pay here lots know that when you're there, you don't have the best credit in the world. You might not even have worthwhile credit. And they also know you probably haven't got much money, but they also know you're probably desperate because of the fact you need a car, don't have much money, got no credit. So what they often do is they've got used cars in the lot that are overpriced, and then they're going to have an interest rate about as close as you can get to usurious without breaking the law. So they might charge you 25% interest on a loan and sell you a car that's worth $3,000, but sell it to you for $10,000. And I know people who've done this, and I've seen it many times. And I say, why would you do that? I mean, you can blue book that car and see it's not worth $10,000. They say, it was the only thing I could get my hands on. They're the only people who'd sell me a car. So, I'm not blaming people for being desperate, but it's unfortunate that people who are desperate will often do things that most rational people would step away from. And there have been articles, and I'm not going to go into this, but the Los Angeles Times a few years ago did a great article where they tracked one car that was bought and sold and repoed 8 or 9, 10 times maybe by one lot in Los Angeles. And what winds up happening quite often is these dealerships actually make their money off the down payment, maybe even the first payment. And then the vehicle just gets repossessed and they clean it up and sell it to the next person. And it goes through that cycle many, many times. And sometimes it goes through a cycle where the people buy the car, they're driving it for 2 weeks and it breaks down. They can't make the payments, they don't have a job, whatever, the vehicle gets repossessed. The dealership washes, waxes it, and gets it running again and sells it as is to the next person. That person buys it as is, breaks down 2 weeks down the road. So it happens over and over again. So that's the cycle you get into. So remember this. The three main parties to the transaction are you, the buyer, them, the seller, and then the third party is the bank. And you don't necessarily normally deal with them directly unless you go get your own financing. But I'm talking about the typical transaction where you're sitting in the dealership. And the dealership says, we just got you approved, okay? The contract originally says you're getting the loan from the dealership, but the loan's being assigned to the bank. If the bank accepts the assignment, you make your payments to the bank. If the assignment fails, then litigation can ensue or other things might happen. But that's the basic thing. But the key here is the bank doesn't own the vehicle. You do. The bank has a lien on the vehicle. They are a secured party. They have a security interest in the vehicle. So that means that if anything happens to the vehicle, they are supposed to be able to step up first and get their money out of it before anybody else. That was what was wrong with Massachusetts. I had someone tell me, they said they don't need to rewrite the law in Massachusetts because the law says owner and the bank's the owner. No, the bank's not the owner. In fact, I did an entire video called Who Owns Your Car? You do. Until it gets repossessed, if in fact it's a lawful repossession. So that's how bank loan works, and I hope you understood it. Questions or comments, as always, comments below. Talk to you later. Bye-bye.